Hello, this is Matthew Chan, and I'm here again with another video with Oscar Michelen, New York attorney.
Hello.
And this is part of an ongoing series of educational videos for our website. And in this video, what we're going to talk about is how you can defend yourself if you find yourself caught in this with the Getty Images settlement demand letter. Oscar and I recognize that some of you are unable to necessarily retain his services for whatever reason, and you may want to attempt to resolve this on yourself. And so Oscar and I are going to talk about some of the strategies that we think might help you if you decide to take that course of action. Right, Oscar?
Absolutely, sure.
So anyway, I'd like to kick this one off, mainly because the origin of the website came about because I decided to take the tact is I wasn't going to hire a $300, $400, $500 an hour attorney over one image. I mean, as far as I was concerned, this is my opinion, I just wanted to clarify that, that I had to use a little bit of common sense, that were these people actually take me to court? Okay, they may not. But I did go through the scenario of getting myself educated, as you well know.
Right.
And having had a little bit of exposure to litigation, I was like, I think I can do this. And, obviously I have to thank you because you gave me a little bit of support during my second response to Getty.
Right.
And which was immensely helpful. And the deal is this. I would say that for people who want to defend themselves, you have to get a little bit of stomach for it. There are some people, their psychological makeup is there. They don't like confrontation, and they're best suited just to hire you. Or some people, if they don't want to hire you, they just have to run and hide, I suppose.
Or settle.
Or ignore, right.
They'll cut a check. Yeah.
Exactly. Or you can ignore it, but we're not advocating ignoring. That's not my style.
Neither
we
is
both
mine.
agree with that, right?
Right. I would not ignore it. It will not go away. You will get continued letters. You will get letters from other third-party collection agencies that they're going to use. You'll get emails.
Right.
And there's no point in continuing the stress by ignoring it.
Right. Well, one thing that you and I agree is if you get that letter, take the image down. Would you say that?
100%.
It is not worth the fight.
There is no image that's worth the fight. Most of these, all of these, are stock photos, okay? So it's not anything unique. It is not anything that's a work of art. It is a thumbnail photograph that you could get at so many other places for $1 or less or free. Go there and get those images. Cease and desist in the use of the image upon receipt of the letter.
And I want to add to the cease and desist. We're not just simply saying you take it off a web page and all that. You totally delete it from the server, no matter how well buried. Delete it from your hard drive, anywhere you can find it. Delete it from archives.org. You don't try to be sneaky about it. I mean, just delete it. It is not worth it because they can poke around and dig in and find the image. And I've heard of people, they said, well, I took it off the webpage. That's not good enough. I mean, it's a headache to begin with. Don't aggravate the problem any further.
Yeah,
Would you agree with that?
You don't need the image. You do want to, in some sense, be careful. Sometimes Getty sends you letters that say you're in the middle of litigation, so that's evidence. So we don't want to be careful if you get those letters not to destroy it necessarily. Get it completely off your web server, your website completely. You can even email it back to Getty if they're so interested in having it.
But you didn't have a copy on your computer when you email it.
That's right. That's right.
So
you want to get it off the archives.org site because the Getty robot, PicScout, could find it off of the archive site. So you want to continue to infringe by having it out there on the internet.
Exactly.
And you want to get that information off there as quickly as possible to honor Getty's cease and desist request, which is a reasonable request.
Yes, it is.
And the only reasonable response is to cease and desist.
Now, do we agree that not only do you do that, you should write a letter letting them know that you have acknowledged your letter and that you've totally deleted it? At least take that off the table.
That should be the first and immediate response.
Okay, from there, what do you recommend?
I would also recommend in that letter, you could put a little phrase that's saying, while not admitting any liability, I did take the image down. You just want to say, I took the image down. That's fine. But you could add that, you know, not an admission, I just took it down based upon your request. Before you even do that, or as you're doing that, one of the things you ought to do is read our site.
Yes.
Become familiar with the issue. Why is this an issue? What are we talking about? Look at the letters that you've written in response. Read the forum posts. There's a good summary there of the entire issue that will educate you about 90% of what is going on out there. So I think that that's the first point. Get educated, read the articles, understand what Getty's legal position is, what our answer to that is, and then when you send a cease and desist letter, you can also say that you feel that they're asking for too much money, that the infringement was innocent, if it was an infringement.
Right.
And that you feel you shouldn't have to do anything more than cease and desist.
You know, there's one thing that I noticed, and I don't think it's changed unless you tell me otherwise, is I do believe that Getty does feel that the majority of people, maybe I shouldn't even say majority, many people, it really is innocent infringement. They never gave me a hard time about that. They never accused me of being willful. And I have to give credit where credit is due. They were actually pretty nice. They absolutely believed me.
Right.
It was an innocent infringement because I gave them so much detail of my circumstances. Now, I don't know legally if that hurts you, but I'm a big believer in being honest. If you didn't do it intentionally, just lay out the circumstances.
Right.
And I think that helps diffuse it a little bit, if not totally eliminate it.
It does, but understand something.
You sure?
Okay.
I know it's no excuse.
Exactly.
I just
right. Not only is it not an excuse, it's not a defense. Let's be more technical.
Right.
And by admitting that you took it innocently, you have made 100% Getty's case. Because now you acknowledge that it was taken, it was on there.
Right.
It's not a big deal because there's a screenshot of it. I mean, you're not really giving up anything. The image was on your website. But just be aware that when you say, look, I took it in, it got on my website through this fashion innocently,
yeah.
You can no longer deny that it was ever up there. Okay.
Right.
So the point is, Getty is being so magnanimous with you because it's irrelevant. That's all. That's irrelevant.
Yeah.
Sure. Okay, you know what? We believe you. Doesn't change a thing. Give me $1,000.
No, actually, that is true. They did say that. It doesn't change it. And,
right.
you know, they
That's
made a
why they
final
can say,
offer.
you know what? We believe you. Okay, so now what do you got?
Yeah.
Okay, because believe me,
Yeah.
if it were an issue,
Yeah.
they would argue with you, that was your agent under the law.
Yeah.
You have an obligation to check. There's things they would answer back to you.
That's a good point.
If it really made a difference
Yeah.
to their claim, they would not be so quick to say, thank you. I'll give you a perfect example. A rival company of Getty's is Masterfile.
Yes.
Masterfile registers all their images. Therefore, they are entitled to statutory damages, the big bucks, attorney's fees, costs. Okay, it's a much different.
And they know
claim.
their position.
Well, of course. So, innocence becomes important then.